Difficult scenarios as a criminal defense attorney. Scenario 1. Your client is going to lie. Your client has a constitutional right to testify in his own defense at trial. But what happens if you know he is going to lie? Lawyers have a duty of candor to the tribunal. This means they cannot intentionally deceive the court. It means they cannot conduct a direct examination of their client when they know the testimony to be false. But what should the attorney do? The attorney also has a duty of loyalty to the client. It would be unethical for the lawyer to stop the proceedings and advise the judge and jury their client is lying. This places the lawyer in a difficult situation. Many jurisdictions have created a compromise that preserves the client's right to testify, protects the attorney's duty of loyalty, and shields the attorney from actively deceiving the court. The solution is to have the client testify in narrative fashion. As a cautionary measure, I would advise a lawyer in this situation that they shouldn't refer to the defendant's testimony in closing argument. Scenario 2. The attorney has a murder weapon. Every so often, an experienced attorney will be given a weapon implicated in a murder. What should the attorney do? He can't throw the gun away, nor can he permanently conceal it. That would be obstructing justice. He can't call the cops and say my client John Doe gave me the gun involved in the A Street shooting last week. That would violate attorney-client privilege and the attorney's duty of loyalty. What can the lawyer do? The lawyer should call the investigating agency and tell them they have an item of interest. When the police arrive, the attorney can say when they got it and conceal from whom they received it. If this occurs, it is imperative that the attorney handle the weapon with gloves, preserve its integrity, and give it to the police in the exact manner it was given to him. The evidence surrender will likely make the attorney a witness at the upcoming prosecution of the case for chain of custody purposes and likely bar him from representing the person who surrendered the weapon at trial. Scenario 3. Representing co-defendants. It is extremely unlikely and certainly not advisable to represent more than one person implicated in the same criminal act. It often presents conflicts of interest. A lawyer has a duty of loyalty to each of their clients. This duty is easily breached in a joint defense by one attorney or law firm. A lawyer is precluded from defending one client by shifting culpability to the other client. A lawyer is precluded from seeking a favorable plea deal for one client if it imposes the slightest disadvantage to the other client. If the matter went to trial, a lawyer couldn't cross-examine one of his clients concerning privileged information. In this scenario, I recommend accepting the person with the greatest culpability as your client and referring the other potential client to a skilled lawyer you know you can work with on a case. The two lawyers can enter into a joint defense agreement with their client's permission and share information and craft a common defense to the charge if they deem it in their client's best interest to do so.